The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover Paragraph 3. Our instructor for this video is Kevin Burke. Let's get started.
All of paragraph 3 is all finance terms. Okay, so buyer represents that funds will be good when deposited with the escrow holder. So that's kind of an important statement. All right, so in other words, when the buyer says to you, here's the check, first of all, you shouldn't be taking a check, but I don't have the money right now, but I'm planning on winning it this weekend in Las Vegas. That's not going to work well. Okay, especially since you know about that now, and the buyer has said when they're doing it here, they're saying by contract that the money is good at the time that they deposit it. And in fact, if the seller accepts the offer, that money now needs to be deposited. And we're going to see in a second that is deposited by the buyer to the escrow company or to the broker's trust fund or to wherever the agreed party is, all at the same time. Okay. All right. So if the buyer tells you that they don't have the money, then you need to tell the buyer, then we need to maybe do this when you do have the money, or we need to have a separate instruction in here that says that you don't have the money and that you're planning on winning it this weekend. Okay. Because the seller needs to have these facts available to them when they make the decision to accept the buyer's offer. Okay. And if you are aware of something inconsistent with what the buyer is stating in the contract, then you want to make sure that you don't become a co-conspirator in the problem that the buyer is about to create. Okay, so buyer represents funds will be good when deposited with the escrow holder. Sometimes they'll take money out like a 401k or something like that, and then everybody knows that's going to take a couple of days before that's going to happen. But we need to make sure that we tell the seller that the money at this moment is not good. A really good example of that is where the buyer is counting on their down payment to come from the sale of another home. And so that's why we need to be checking later on. We'll see, we're going to check paragraph number 4 that says that they have to in fact sell to buy. Okay. All right. So initial deposit, when I'm looking at my form here, paragraph number A, I'm going to pull up my annotations really fast. Initial deposit, here we are. Deposit shall be in the amount of. Now, how much is that going to be? I don't know. That's going to be, the conversation I have with my buyer is you need to make it an amount sufficient to compel the seller to accept your offer. If you're writing an offer on $1 million property and you're only going to be putting down $10,000, then the seller might take into consideration the fact that you don't have a whole lot of skin in the game, as we say, right? So, so tell the buyer, a lot of times what we do is we'll tell the buyer, well, if everybody agrees to liquidated damages, then the limit of your liability could be, we never say it is, even with liquidated damages, could be the 3% of the purchase price or the deposit actually paid, whichever is less. Okay, so, but if the seller sees a deposit of 3%, they're probably more than likely to take that offer than if they see $10. But even the buyer could put down on my $1 million property, the buyer could put down as an initial deposit. That's why we changed this language here. Initial deposit, they could put down $100,000, for example, and then of course the risk of their liability would cap hypothetically at 3%, assuming everybody agreed to liquidated damages and everything went well, then they would have a limit of their liability. So as we will cover later under liquidated damages, in a lot of cases, the buyer is, it probably doesn't want to initial liquidated damages if the market is continuing to improve, right? Because there is no damage to the seller. So we'll get into that when we talk about liquidated damages. It is clearly a paragraph that is not what people think it says. So, okay, so our initial deposit then, whatever that figure is going to be, we're going to figure that out. And we're going to have the buyer do that. And again, the buyer's direct deposit, we usually do, the standard practice now is to start with this part of the paragraph, and the buyer's direct deposit shall be buyer deliver deposit directly to the escrow holder, unless you tell it otherwise, by electronic funds transfer. And we changed that. We used to say wire transfer, but there's a lot of ways to transfer money, and wire transfer is just a form of an electronic funds transfer. It can be, there are other ways to send money. Could be that the buyer wants to send a cashier's check. And by the way, the standard now today is electronic funds. That's just more common than anything else. And that's why we put that first. Buyer could do a cashier's check, buyer could do a personal check, or whatever, bring in a wheelbarrow full of pennies. You know, I don't know what they're going to do, but that's certainly something that, hey, Linda. Linda's wandering around. Okay, all right. All of that within what? 3 business days. And remember what our contract says in definitions in paragraph number 22, all days are calendar days unless specified otherwise. And that's why we have here 3 business days. So today is Thursday. Your offer comes together this evening at 5 o'clock. Then what is 3 business days? Well, 3 business days would be on Tuesday, correct? All right, 5 days from today, but Tuesday would be 3 business days. We'd have Friday, we have Monday, we have Tuesday. I don't know if there's a holiday on Monday. I don't think so, although I know we have Memorial Day coming up at some point. Okay, so within 3 business days after acceptance, or if you've got some other idea when the money's supposed to be brought in. Sometimes the buyer, you know, wants to bring in the money later, but they need to have a contract with the seller that says this is when that's going to happen. Okay. All right. Paragraph number 3A2 is what used to be in the contract. And I talked to Neil about this because I had pretty much lobbied to have paragraph number 2 eliminated because of all of the trouble I was seeing us getting into as real estate agents. We were getting into because we were handling the check. And Neil's comment to Neil Kalin, a staff attorney at CAR, and his comment was a good one. He said, well, you know what, Kev, he says, it's just going to be one of those situations where, you know, one of our agents will take a check, and then when they do that, then, you know, we need to have that paragraph available to them, and that's why they left it in there. I kind of wanted it completely out of there, kind of under the assumption that, you know, I don't want us taking checks, and that was the problem that it was creating. But, you know, all right, this isn't going to tell you to take a check. This is just going to say if you take a check. Okay, so now I'm going to tell you, watch out, lawsuit avoidance, watch out. You'll have that situation where you'll write an offer and the buyer will say, well, I want to give you a check. And you're going to say, well, our contract says no. And then the buyer says, well, how about if I give you a copy of a check? If you check paragraph number 2, you need to have the original check, because if you have a copy of a check, you don't have a check. I don't know if you've tried to cash a copy of a check lately, but that's not going to happen. We're going to talk about that in a minute. So the buyer's deposit with the agent. Buyer is given the deposit by personal check, that's the default, or whatever, to the agent submitting the offer, or to who? Okay, could be or to escrow, made payable to, and then a lot of times we have it payable to the escrow company or the to the title company or to the broker's trust account. So remember, if you're going to do number 2, you can't leave any blanks in there. You gotta let us know who it's going to be made payable to. And then I'm going to tell you again on the subject of the check, I want you to be careful with that. I see it all the time, you know, great lawsuit material. Here's the check. The agent instructs the buyer to write out the check, leave a space in the front, because we don't know who the escrow company is going to be yet, because there may be offer, counter offer, that kind of thing. And so they have them leave a space, and then it says escrow company, and then the buyer signs it, and the buyer puts a dollar amount in there, and then the agent comes back later on and fills in the name of the ultimate escrow company. Okay, that's fraud. All right, you have altered a document over a signature. Please don't do that. I know nobody here would do that, but you know, sadly, a lot of times we have people that still think that that's the way to do things. I'm going to tell you, incredibly dangerous. It's fraud. You know, you're going to have a problem with that. You know, if you do it, let me know. You know, I've got lawyers. So, okay, made payable to, and then whoever the escrow company is, you have to be specific. And, you know, sometimes I'll see people writing their offer and they'll say, you know, seller's choice. Remember, the contract fails for vagueness based on terms. And so if the term is not specific, if you haven't put in there what escrow company it's going to be, then your contract fails for vagueness. Okay, so don't do that. You know, come up with a or come up with an escrow company, put in the name of the escrow company, and it can always be subject to a counter offer. But if you put in seller's choice, then there must be a counter offer in order to define the term. And I think you're just opening up the door for that. Plus, I think that you're not representing your client when you're letting the other agent write your offer, because essentially that's what you're doing. When you put in seller's choice on things, you're asking the other agent essentially to write your offer for you, and now you are no longer representing your buyer. Okay, so that's just going to be one of those little things that I have to deal with when it comes to when people get in trouble, and I just kind of like you to avoid having to do that. All right, but you do, again, whatever your broker tells you to do. I'm good. Okay, the deposit shall be held uncashed until acceptance. Right, so you have acceptance, so you'll have offer, acceptance, and then delivery back to the party to be bound, and then deposited with the escrow holder. We're just going to assume that it's going to go to an escrow holder. In other states, we call them settlement services and things like that. Within how much time? 3 business days after acceptance, or could be another time, whatever that time is. But again, we need to tell the seller what our plan is at the time of the offer. All right. Okay. So here, caveat here, deposit checks given to the agent shall be an original signed check and not a copy. All right. See, I just had one a week ago, and it's like, okay, so some people got to get into the 90s, but the fact of the matter is that, that's going to get you in trouble because you said you had the check, and unless you're willing to pony up 10 grand or whatever the amount of the check is that you don't have, then you're going to have issues there. So again, if your practice is to take a check from the buyer, that's old school. I get it. It's okay. Then just be prepared. Make sure you have the original check. Okay. And then finally, my little note: initial and increased deposits checks. So there's a typo right there. Deposit checks received by the agent shall be recorded in the broker's trust fund log. And I like the fact that CAR put that in there. I mean, it's something that we all know, it's on the state exam. When you got your license, it was on the state exam. Anytime you touch a check, it must go into the broker's trust log, not your trust log unless you're the broker, but in the broker's trust log. So I've walked in, I've been management at 3 of the largest real estate companies in San Diego, and I've walked in each time and horror stricken with the status of the trust fund log, and it's out in the middle of the kitchen, in the office for everybody to see it. It's got live checks in it, things like that, and it just causes palpitations for those that know what we're doing. At the end of the day, the log can be there. The original check should not be there. If you did take the check, then you need to log the check. The copy goes in there along with your trust log. That's a specific form issued by the Department of Real Estate. And then the original check goes to your broker. And so even in one of the companies I was working with, we actually cut a hole in the door of the broker so that on the weekend you could walk in and put that check in there. Because when we get in trouble, it's because the notations in the trust log are not in chronological order, because you didn't bring it in until Monday, and 3 other people filled theirs out on Saturday and Sunday, but you got yours on Friday. So we want to make sure we do this thing the right way. And like I said, it's probably just as easy if you don't take a check. But again, and if you want to have your broker call me if they're having issues, let me know, and I'm happy to help. Okay, let's take a look at paragraph number 3B. Now we're going to talk about the increased deposit. All right. So as a matter of practice, I don't see this a lot, but I do see it from time to time. An increased deposit is a deposit other than the initial deposit. Okay. So it's a deposit that comes in later. All right. So, usually we have the money that comes in as an initial deposit, and that's why they changed the name from earnest money deposit. We have another deposit that may come in at a later time, and that's this one. And then we have the final down payment and everything brought in by the buyer. Each one has a different law associated with it. Okay, so my increased deposit, let's talk about that. And sometimes I've seen it attached to removal of contingencies, things like that. Anytime you agree to an increased deposit, it's going to start another process in motion. So buyer shall deposit with the escrow holder an increased deposit in the amount of whatever, all right, within so many days after acceptance. A lot of times I'll see like 17 days, they'll tie it to the contingency removal for the physical inspection. most of your inspections, are over by 17 days, except those that like your loan for 21 days, and then for other things that you don't have yet. So if the buyer doesn't have the CC&Rs, then they get 5 days from receipt, and that may take you past 17 days. So sometimes I'll see people putting in 17 days. Again, I'd be very careful about this. We don't do it as a matter of practice in our office, but that you do whatever you need to do. Sometimes people do it to try to make their offer look more interesting. All right, I get that. If the parties, this is important, if the parties agree to liquidated damages in this agreement, if they agree, because it's not required, even though we have places to initial, doesn't necessarily mean we initial them. Okay, remember, it's a legal decision on the part of the buyer whether or not they want liquidated damages to apply. Same thing holds true for the seller. We're all trained that you always initial it. That's not true, but okay. They also agree to incorporate the increased deposit into the liquidated damages amount in a separate liquidated damages clause. And the point is this: if everybody has agreed to liquidated damages, then it only applies to the initial deposit. If you want the increased deposit to also be applied, to also have the liquidated damages provision applied to it, then you have to use the separate CAR form RID. RID stands for receipt for increased deposit. Okay, that's what that stands for. At the time the increased deposit is delivered to the escrow holder. So anytime people bring in money in other than the initial deposit, we need to make sure that if they want liquidated damages to apply. If they don't, then we just sue for actual damages, right? But that's why we have that, and it's a reminder to all of us that if you're going to bring in money later other than the final money, then you need to make sure that you have and you want liquidated damages. You had the initial deposit apply. Do you also want the liquidated damages provision to apply to the increased deposit? Okay, everybody good? Should be in good shape on that. I gotta move my face out of the screen here. All right, let's go on. Sorry, I should look. Thank you. Yeah. Okay, good. All right. God, I'm glad you caught me with that stuff. Sheesh, I could have gone on all day. I could talk about this stuff forever. Let's take a look at paragraph number C. All right, number C. All cash offer. Now, all cash offer, did I miss something? No, I did 3A and 3B. Okay, 3C. All right, all cash offer. All cash offer means all cash. All right, it doesn't mean hang on a second, put this up here. It doesn't mean I'm removing the loan contingency. Okay, that comes later. All right, if I want all cash, my buyer is paying all cash for the property. Now, I've had people say, well, to the seller, it's all cash anyway. Yeah, I know, I get that. But in this case, if I'm paying $1 million for the house and I'm bringing in $1 million in cash, then I'm going to check this box, okay? And as you know, in zip forms, when you check this box, it wipes out, it grays out your ability to fill in the rest of the financing because there isn't any. It just assumes all cash means all cash, which means you're bringing in cash, okay? So in my all cash offer, no loan is needed to purchase the property. That is inconsistent with no loan contingency, all right? You follow me? So this just says no loan is needed to purchase the property. The offer is not contingent on the buyer obtaining a loan. So don't check this box if your buyer has to get a loan and intends to just remove the loan contingency up front. That's got its own pitfalls, all right? So that you wouldn't check this box. This is only for cash. Written verification of sufficient funds, just like you would for verification of deposit, okay, for this transaction is attached. That's the default language, says it is attached to this offer, okay? All right, so buyer shall, or statement here, or check the box, buyer shall within 3 days or another whatever, 5, 10, 20 days after acceptance, deliver to seller such verification. Remember, acceptance is a very important time because a lot of most all of our contingencies trigger off of that time, okay? Deliver to the seller that verification, all right? Remember, hands off by us. We want this handled between the buyer and the seller. We want this to be between the parties. We are merely the facilitators, okay? All right, now, I think D is gonna be on my next page. Any questions so far? No, we're good. Okay, all right. So let's talk about the loans now, all right? Let's talk about the money, okay? The majority of transactions that you're going to be involved in are going to involve some type of financing. At one point, 38% of our transactions were cash, and that was during probably what's arguably one of our worst economies between '05 and '09. And where all the cash come from? I kept saying, I think that's why we're having the problem we're having, is nobody's recirculating their money in the economy. They've got all this cash. People are paying $1 million, $2 million, $3 million. Now, you and I are used to this, but if we go someplace like, Chicago or Des Moines or someplace like that, I mean, the financing is the way it is. People just aren't paying cash in these places, okay? All right, so let's talk about my loan. My first loan in the amount of whatever that figure is. And so you need to do the math. Now, we have a really good form called the financing worksheet. So it's a purchase agreement, residential purchase agreement worksheet put together by a guy by the name of David Perry out of San Francisco. The guy's just brilliant. I mean, I love David. And he created another form where you can use that what's it called? The residential purchase agreement worksheet. You can RPAW. You can go to that form, fill in, it'll do all the math for you, so you're not messing this form up here. When we freehand this, then I start to see crazy. I've had lenders fill out purchase agreements and the math is wrong. So, you need to make sure that the math is right. So use the form. It's a good one. The assumption here, this loan shall be conventional financing. That's just the assumption. The majority of our loans, excuse me, are conventional financing, or it could be FHA, it could be VA, or it could be seller financing, in which case you would use the SFA form. I haven't even brought that in here today. Probably should actually show you what that form looks like. I didn't have it in the queue. Let me see if I've got it in here at all. I don't even have it in the queue, so that's good. I don't want you using it. Okay. All right. So let me take us back to where we are. Now to mess that up. All right. God, sometimes this program does not work the way it's supposed to work. And that's because I am not using the mouse. There we go. Okay, we're back. All right, everybody good? You should be able to see that. Yes, you can. Okay, good. All right, so the SFA form, seller financing addendum, is pages long. You just got to read it one time and you will be cured of any attempt to ever create financing between the parties. Remember also, you don't want to become an arranger of credit, and you got to be really careful about that. In real estate, you could do this. Please check with your broker. The advice is probably going to be not to. We don't allow it in our brokerage here, okay? Or it could be assumed financing, which means that the buyer is going to assume the seller's underlying liens. All right, that would be this box, okay, the AFA form, or it could be something other. That's the part I call creative realtoring. That's usually when I get called in, okay? This loan shall be at a fixed rate not to exceed. If you don't fill in the numbers, then it's akin to not having a loan contingency. So you need to protect your client. And I get pushback on this all the time. People say to me, they say, well, I don't want to fill it in. I want them to take best prevailing rate and terms. Well, that again is the same as not having a financing contingency. And remember, you don't want to suffer the lawsuit from your own client when you're writing your offer. You need to put in limits. All right. And remember, these limits are only good during the financing contingency period, right? So the financing contingency for the loan is 21 days. So if you put in here 5%, and I think that's a reasonable figure. I think our template says 5%. You put in 5%, and interest rates go above 5% during the 21-day loan contingency period, then your buyer has the ability to exit the transaction based on the fact that the interest rates have exceeded 5%. Now, I hear people say, well, I want to make my offer a strong offer, so don't fill anything in. Okay, but again, you are putting your buyer at peril, and a strong offer versus a very weak position are two conflicting things. You need to protect your buyer. Your buyer can always say, no, I'm not going to exit the transaction, even though they went to 6%. But remember, it could very well be when interest rates go up 1 point, then we lose 1,000 buyers in our market in San Diego. Okay, so protect your buyer, have it in there. They can use it or not use it, but you definitely, and again, we're going to be doing a counteroffer class on the fourth Thursday of this month, how to handle counteroffers, multiple counteroffers, and backup offers. Okay, and so be aware that you don't want your buyer, it's not in their best interest, let's put it that way, to accept a transaction with a seller where the buyer is agreeing to take whatever loan is available at the time, right? Because they may not be able to get it. What happens if interest rates go to 6 and now they're priced out of the market and they can't get financing? Guess what? Their deposit's at risk, all right? And you did it. So let's make sure we fill in something there, and then you may end up in an educational process with the other agent. If you get into challenges on it, let me know. I'll give you the language. But you know what? It's just you can't agree to it. Okay. All right. Or it could be an adjustable rate mortgage, and then I don't know what that is. Now, frankly, interest rates today are as low as they have been. I was knocking on doors when they were at 28%. Somebody beat that for me, will you? 28%. So for me to see the interest rates down in the threes is just, I have a loan myself on a house. It's at 3.75%. That's crazy. Okay. God, buy a house. Anything you can do. Okay, then we also have at the bottom of this, we have regardless of the type of loan, buyers shall pay points not to exceed. Remember, we're putting a limit on things. In our template, we put in 2 points of the loan amount because there are going to be lender fees, and the lender needs to quote the buyer what the fees are going to be. And so we put in the 2 points. The lender gets a copy of the contract. They can see what it says. And then if there's a problem, they can let you know. Okay. All right. Is everybody good with that? Let me see. I'm checking for questions really fast. I had to speed it up a little bit since I got distracted earlier, and I apologize. So, okay. Number 2, is there a second loan? Now, we just brought this language back in a couple of years ago. We used to have it on another form called a purchase agreement addendum, but then we realized we were seeing more seconds at times of purchase, and so we incorporated it in the offer again. All right, and so there you'd have a dollar amount in here, and then the same kind of rules in here. We're not going to have the assumption is it's going to be conventional financing because FHA and VA don't really normally do secondary, second loans on property. You certainly wouldn't have an FHA first and an FHA second. Okay, and then, or it could be a seller financing, or it could be an assumed financing, or again, it could be an other, okay, and then all the same kind of stuff without, hitting us with the Department of Redundancy department. We've got, in fixed rate, or it could be an adjustable rate, and then how many points? 2 points, okay, and then let's get into the third paragraph number D3. Now we're going to talk about that. We're going to dig in. So if you check the box up here, FHA or VA, then now number 3 is also going to apply. For any FHA or VA loan specified above in 3D1, buyer has 17 days or however many after acceptance to deliver seller a written notice, and that's CAR form FVA, of any lender required repairs or costs. I never see this done. You need to protect your buyer. There is a form, the FVA form, and that form is much like a request for repair, but it is separate from the request for repair. And this is the form you're going to send this over to the lender, and you're going to say, give me a list. I want to know, what are you guys going to require to be repaired, because we've got an inspection coming up and all that kind of stuff. And if it's going to be a contingency of the loan, you need to make your lender work on the loan in the beginning of the transaction and not wait until the last week of the transaction. You want the lender working on it early, and the lender needs to tell you if there's going to be any repairs, because if your buyer and your seller agree to repairs, agree to a whatever on repairs, and then the lender comes along and requires more stuff, the seller may dig in the heels and say, I'm not doing it. All right, and so you need to make sure you get that over to the lender and say, this is what's going on. I assure you they expect it. Okay, but they're more used to it not coming their way, and then everybody will just kind of work it out. Listen, you need to hit this with a surgical strike. When you are doing a real estate transaction, you need to represent your client to the best, to the nth degree, and that's how we do it. That's one of the ways that we do that. Okay. All right, so of any lender required repairs or costs that the buyer requests the lender to pay for or otherwise correct, okay? Seller has no obligation to pay or satisfy lender requirements unless agreed in writing. You see what that says? So if you didn't use the FVA form or something equivalent to it, the standard is the FVA form, then guess what? Guess who pays for things when you don't do your job? You're paying for it, okay? Just like I always tell you, anytime you leave a blank, you're paying for it, okay? It's going to be you. Everybody else is going to go, I'm paying it, all right? And this is one of those times, okay? So please do me a favor. When you do an FHA or a VA, make sure you're using that FVA form. That is not the FAA mandatory clause form. It is the FAA repair form, okay? All right, the FAA FHA VA, a mandatory clause that I just mentioned is my FVAC, and that shall be part of the agreement. That should go over with your offer. And that document merely says that, here's the purchase price we're offering. If the property doesn't appraise for that amount, notice to the seller, you're probably not going to be able to keep the buyer's deposit, and especially with a VA transaction. And it's kind of a neat little clause, neat little paragraph. I really like it. I'm glad we created it probably about 12, 13 years ago. And so please make sure you're doing your job. If you're doing an FHA or a VA, and I know we all want to do the $5 million deals, but guess what? You could be doing a $5 million VA transaction, all right? But the FVAC form needs to go over with the offer. The FVA form needs to come over within the contingency period, the inspection contingency and the repair contingency period, so that in case the lender has any additional repairs that they're going, repairs or costs that they're going to require. Is everybody good with that? That's a lot of information. Okay, all right, let's move on to, where did I go? Now I can't move. All right, because I'm not on the form that I'm supposed to be on. Click, that'll kill that. All right, hang on a second. We'll bring it back up again. Where are my forms? What is that? My paragraph 3C. It happens sometimes. Okay, here we go. We're back to where we are. Bingo. Now you should all be able to see. That was 3C. I'm going to take you, there's D. Now let's take a look at E, F, and G. Okay, so additional terms, additional financing terms. So now a lot of us, we will use this part of the document. I'm just double checking to make sure you can see the same thing I'm looking at. Okay, we will use this part of the document to put in buyer has been pre-approved for a new loan through, or we'll put in credits, if any, that the buyer is expecting the seller to give them, or any kind of special language. That's what we're going to put in here under additional financing terms. And you will notice, I lost my annotation. You will notice that there's nowhere that this paragraph number E does not have a corresponding dollar amount over here. This is just going to be talking about any additional terms that you want to cover. Paragraph F, on the other hand, needs to line up. So whatever you have in the loan amount, whatever you have in the initial deposit, the balance, whatever's left to accomplish this number, they all have to add up. And this is what I frequently see when we don't use the program properly, or we freehand it. This is where I see a problem. Okay, so balance of the down payment or the purchase price if there was no down payment. Okay, remember, deposit goes towards the transaction, the down payment goes towards the loan. Okay, in the amount of to be deposited with the escrow holder pursuant to escrow holder's instructions. Okay, all right. And then finally, my purchase price, everything needs to add up to this, right? It's up in paragraph number 1C. It's down here, and all the numbers in the column on the right-hand side have to add up to this number. Okay, everybody good with that? I'm going to move forward. Seeing no questions, I'm going to move forward. Let's talk about H. And a whole bunch of stuff in here. And believe it or not, we're going to get through this pretty quick. Verification of down payment. Bingo. Verification of down payment and closing costs. I'm going to move myself out of the way again. Buyer or buyer's lender. Now, this is the part where we like the buyer's lender doing this, because we really don't, as a broker, we don't want the buyer's personal information in our file. Okay, because if it is, then we got to go to, leaps and bounds to protect it. We like the lender getting that information. So what we normally do is have the lender write the pre-approval letter to include the language that says, okay, that I, the lender, have verified the source of down payment and closing costs sufficient to close this transaction. I like the lender writing that. Train your lender to do things like that. Okay, the lender's got to do it anyway. Right, and for the purpose of getting the loan put together, they've got to have verified all this stuff, and that's for their own well-being. Okay, so pursuant to 3J1, and we'll get to that in a second. Within 3 days, I think you should be sending over your pre-approval letter at the time of the offer. That's just the way we do business. I know as a listing agent, we don't. We usually send it back and say, get us a pre-approval letter. Seller wants to see that, because the seller has said to us, we want to see it before we're going to consider the offer. So 3 days, whatever, written verification of buyer's down payment and closing costs. And then we check the box right here that says verification attached. Don't check the box if you don't have the verification, okay? Let's take a look at number I. We're going to be talking about my appraisal now. Now, one of the things that we did in this version of the contract was we separated the appraisal contingency from the loan contingency. So the appraisal contingency, your transaction by default is contingent on a written appraisal of the property by a licensed or certified appraiser, not by you, okay, at a price no less than the purchase price, okay? All right, now, I can tell you, if you decide the buyer wants to say, I don't want it to be contingent on the appraisal, then you need to have a letter, a confirming letter to them that says that, you know, again, subject to your broker's approval, you might want a letter to the buyer that says that you are acting against our advice. We think you should get leave the appraisal contingency in there, because what happens if the property doesn't appraise? You know, then the buyer's on the hook for the difference between the purchase price and the appraisal amount, in addition to their down payment. So it causes all kinds of harm, and so we want to make sure we get that covered. Buyer shall, okay, in writing, remove the appraisal contingency or cancel. It is a contingency of the transaction, and in this case, 17 days or whatever days you put in there. We'll notice in a second when we get down to the loan that the loan contingency is going to be 21 days. And the reason that we did that was because we didn't like the appraisal and the loan coming in at the same time, the loan contingency removal at the same time. So essentially we're giving the lender 4 more days to sort out the appraisal and to get the loan approved as well. Okay, so all right, so let's take a look at loan terms. So loan application within 3 days. Okay, again, if you've had your buyer pre-approved, and I think most of us are doing that now, we won't even take the buyer out in the car unless they've already got the approval. So loan application's already been done. Okay, but this is just going to describe all the things that are necessary. Written application. I've had lenders send me pre-approval letters and they haven't even taken the Fannie Mae 1003 yet. Fannie Mae 1003 is a standard loan application form. They hadn't even done that yet. And frankly, they're not allowed to order the credit report without a writing from the buyer that authorizes them to do that. And that's contained in that form. So buyer is pre-qualified or pre-approved. And if you're presenting the offer yourself, which I think you should, I would probably circle pre-approved so that it emphasizes the fact that the buyer is not just pre-qualified, that they're pre-approved for the new loan specified in 3D, okay? All right, so if it is an adjustable rate loan, the pre-qualification or pre-approval letter shall be based on the qualifying rate, not the initial loan rate, and then again, letter attached. Okay, everybody good? Listen, you need to get in good with the lender. The lender is your friend. The number one reason transactions fail to close escrow is because the buyer couldn't get the loan. And I'm going to say that, and you know what? Bells need to be going off. It's not the physical inspection. It's not the repairs. It's the loan. So if you haven't had your buyer talk to the lender, then it might be a good time to do that as you're getting started in the transaction, okay? All right, loan contingency, number 2. Buyer shall act diligently and in good faith. We added that word good faith, and that changed the whole dynamic of the contract, okay? So if the buyer's saying, I'm going to act in good faith, and then what do we have? We have lawsuits over bad faith negotiation, you know, things like that. So, and we did that on purpose. I'll never forget a big attorney out of North County saying that, and he was right. You know, the buyer is saying, I'm going to try hard to get the loan, not wait until the last minute to get the designated loan. Buyer's qualification is a contingency of this agreement, and the seller is relying on the information that the buyer has given them unless otherwise agreed in writing. So we're just not going to do an otherwise agreed in writing, okay? Question, can buyer request for loan approval before appraisal work? Oh yeah, there's different stages of loan approval, right? So you have DU, you have desktop underwriting, you have you know, all kinds of different underwriter approvals, things like that. A standard approval means that the lender has verified the source of down payment and closing costs. They verified deposits, verified employment, verified, you know, income, verified all these things, okay, that's my standard loan approval. But if you want to really go large on it, then get an underwriter's approval, because they're the ones who are going to be ultimately making the decision on whether or not the buyer is going to get the loan to save the cost for the appraisal. Yeah, absolutely, Don. Good suggestion. That's absolutely what you should do. Why waste everybody's time, both the buyer and the seller, and your time by working with a buyer that doesn't have a loan and can't get a loan, okay? Trust me, there's plenty that they can do between now and the closing to mess up their ability to get the loan anyway. And Linda said that we're going to write a book. We're going to write a book on what can possibly go wrong, between the time that the loan funds and the time that it records. There's a lot of things that can go wrong. And you thought it was over at the funding. It's not over at the funding. So great question, Dawn. Thank you. So buyer's is a contingency unless otherwise. If there is no appraisal contingency, remember up here, or the appraisal contingency has been waived or removed, then failure of the property to appraise at the purchase price does not entitle the buyer to exercise cancellation rights pursuant to the loan contingency if the buyer is otherwise qualified for the loan. See, a lot of times what would happen is we would, in the old contract, we would remove the appraisal contingency and we would say, that's okay. If we can't get the appraisal, then we can't get the loan. We'll just get out because of the loan contingency. That doesn't work here. We specifically address that issue. The appraisal contingency and the loan contingency are two different things. So if your buyer removes the appraisal contingency and later on they can't get the loan because the appraisal didn't come in, then their deposit is going to be at risk. Please do not tie those two together. I always know when I'm working with an agent that's been around for a long time because they think the two of them are still the same and they haven't taken this class. And so it's important to remember that they are two different events. If the buyer removes the appraisal contingency up front, okay, and then later on can't get the loan because it didn't appraise and they were otherwise still qualified to get the loan, the only thing was the appraisal, guess what? You're going to lose, okay? Losing argument, all right? Okay. Buyer's contractual obligations regarding deposit, balance of down payment, and closing costs are not contingencies of the agreement. So, the contingency, the money itself, bringing in the initial deposit is a contingency, all right? But the other money is not. So guess what? If they spend it or they do something stupid like buying a Porsche, not that buying a Porsche is stupid, but they buy it right before remember, you always get house first, personal property later. Don't buy the washer, dryer, and revolving credit. In some cases, your buyer is tight to begin with, and then they go out and they do revolving credit purchases, and they fry their own credit score. So, it's part of our 10 commandments of thou shalt not buy the Porsche before the loan closes, before the transaction closes. Okay, everybody good with me so far? All right, let's take a look. I've got, what am I doing? I got 35 minutes, 40 minutes. All right. Not that I want to take it all. Okay. Loan contingency removal. So now again, what I said earlier, remember up here, my appraisal contingency is in 17 days, but my loan contingency is in 21, unless you modify it. And the reason that we had that is because we went to the lenders when we created this form and we said, how would you like these forms to look? I mean, give us the way that it would make it the easiest for all of us so that you can do your job. Listen, I am of the opinion that if you give the lender 21 days, they're going to take 21 days. I'm just of that opinion. They'd rather have 45 days. They tell you they can't do it. Yes, they can. It's just they're currently working on the fires that were created before on the other transactions that they've got going on. So I'm sympathetic to that. But at the same time, I think 21 days is plenty of time. Now, it's always possible that the buyer might have some situations that are going on that may require more days. If that's the case, then put in the more days. Just remember, you got to sell it to the seller and you got to get past the listing agent before you sell it to the seller. Okay, so within 21 days of acceptance, as specified in paragraph 14, that's time for removal of contingencies, remove the loan contingency or cancel. Those are the only two options. So within that 21-day period of time, the buyer's got two options. And remember, they have to be what? Good faith reasons for exiting the transaction. You can't just say, God, I had an agent say to their client the other day, well, my buyer can get out of it for any reason for 17 days. And I go, that is not the case. I will assure you of that. And you know what? If you're going to play that, bring it on, because it's a losing case. All right. The buyer, there is no such thing as a 17-day free peak. I'm giving you language that people used to say, 10, 20 years ago. And I still have people say it. It's like there is no free peak. They have to have a good faith reason for trying to exit the transaction. And then it's going to be an argument. It may be a trier of fact that has to determine whether or not that is a good faith reason, okay, or whether they were negotiating in bad faith. Okay, all right. So that being said, remove it. Blah, 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 remove the loan contingency. If there is an appraisal contingency, oh God, it just keeps getting deeper, right? If there is an appraisal contingency, removal of the loan contingency shall not be deemed removal of the appraisal contingency. You see, removal of the appraisal contingency is independent of the loan contingency. Removal of the loan contingency is independent of the appraisal contingency. The two are not linked. Okay, if you learn nothing from this page, this is the most important thing to learn, and that is that and good faith, right? The two of them are not linked. And so, if you're newer in the business, God love you. I always say, newer agents are easy. Sometimes we don't have a lot of bad habits to break, right? But sometimes we hear things from other people and they're just incorrect. So please make sure you check with your broker about the broker's position on these things, all right? If you are the broker, then thank you for being here today. Okay, no loan contingency. This is what we talked about earlier. This is not all cash offer. No loan contingency says, I got to get a loan, but I'm willing to make it not a contingency of the agreement. Okay, so let me move my pretty face again. I'm showing up down in the corner here. So if the buyer does not obtain the loan and as a result does not purchase the property, seller may be entitled. So CAR and I are alike on that. I always say your deposit is at risk. I never say you're going to lose your deposit. I never say that, right? Because it's not necessarily true. It could be that the judge says, no, you don't want to lose your deposit. We like you, whatever. Okay. All right. So seller may be entitled to the buyer's deposit or other legal remedies. And remember, in our classes, I say remedies is a term of law. It's a year of law school. Please don't use that in a sentence. That's like saying breach of contract, damages. Those are legal terms. And you don't want anybody coming back later on and say, well, he's giving me legal advice. He said breach of contract. Okay. Stuff like that. Okay, let's take a look. Lender's limit on the buyer credit, because this is also interesting what they did in here. And again, this is the contract. This contract's been around now since 12, right? Nobody ever reads it, right? So what's the lender's limit on repairs? So we're going to talk about two different kinds of credits, okay? So any credit to the buyer from any source for closing or other costs, whatever you want to call, is agreed to between the parties is called a contractual credit. So the buyer asks the seller to give them 3% towards their closing costs. Excuse me, it's never towards repairs, right? The lender doesn't want to see towards repairs. They want to see towards closing costs or something else. And part of the reason behind that is that the lender doesn't want it to appear that that the seller is helping the buyer with the down payment. That's why contractual credits will be limited. Okay, but go ahead, agree to 6%. Let's see what happens. Okay, so contractual credit shall be disclosed to the buyer's lender. Please don't be sneaky about this. I've had people do, little side things, it's like, please don't do that. I definitely, and there's a movie in this. It's just funny what people will do. And in my cases, I've often said, what were you thinking when you did that? It's like, that was really bad. Okay. All right. So let's go ahead in here. I'm having too much fun. Moving that up out of the way. Okay. So shall be disclosed to the buyer's lender. Listen, do not, it's just like you don't lie to your lawyer, do not lie to your lender. They're going to find things out. I had a transaction back in 1977, and the buyer, I'll never forget, the lender found out the guy had child support payments up in Wyoming. Yeah, it was even popular back then. And so the lender says, oh, you're going to have to pay that off. The buyer says, I can't pay that off. And how did you find out about it anyway? So don't lie to your lender. Your lenders are going to find stuff, and that shouldn't be the reason for not lying to him. It should be because, it's not right. But, the lender's going to find it. Okay. So, please don't lie to the lender. All right. And please don't you get involved in the buyer's lie to the lender. So you need the separation of powers here. Okay. If the total credit allowed by the buyer's lender, called the lender allowable credit, is less than the contractual credit. Okay, so in other words, the lender says you guys can agree to whatever you want to agree to, but we're only going to allow this. So contractual credit it cannot be greater than the lender's credit. Okay, the lender's going to put a ceiling on what the total credit can be. And remember, that's going to be important. Be careful about negotiating it up front, because then later on, when it comes time for repair requests, you may not be able to add a credit. okay, because you may exceed the lender's allowable credit, because the lender's the one giving the loan, and they're going to say, we're only going to allow you to get this much contribution from the seller, otherwise we think the seller is helping you with your down payment. All right, is everybody good with that? That's probably the easiest way to explain it. Okay, so then what happens next? Then one, the contractual credit shall be reduced to the lender allowable credit, okay? So in other words, it may not exceed the lender allowable credit. And two, in the absence of a separate written agreement between the parties, there should be no automatic adjustment to the purchase price. I think I should go into the next page here, right? Let me see here. I think I can go to the next page. Is that covered on the next page? Nope, it isn't. Darn it. All right, messed that up. Okay, so back to my language. Sorry if you can't see that. Let's see if I can raise that a little bit. There we go. Can you see that okay? The purchase price to make up for the difference between the contractual credit and the lender allowable credit, okay? No automatic adjustment, all right? Everybody good? Okay, so in other words, what's the lesson? The lesson is that whatever credit you agree to up front, I would check with the lender up front just to make sure that you are not committing the seller and the buyer to a relationship with each other that that the lender is going to stop. Okay, because remember, the lender's credit is going to take precedence. They're giving the money. They're the ones with the money. Okay, so let's be very well aware of that. Okay, and that's 5. All right, so let's talk about our last little paragraph in here. I can't believe I did. Am I good or what? Look at that. I got the whole thing, even after my long diatribe about what contract you use. So let's take a look now. Let's take a look at our buyer stated financing. So what is buyer stated financing? This is going to be the paragraph that's going to be the gotcha. This is going to be the catch-all paragraph, okay? So in buyer stated financing, let me get my annotation back. In the buyer stated financing, all right, the seller is relying on buyer's representation. Now, you don't need to be a lawyer to know that that's called detrimental reliance, justifiable reliance. The seller is relying on what the buyer's telling them, okay? It's not like you're buying a car. You know, you're buying a car, we all know we're getting somebody else's problem, right? Okay, but the seller in this case is relying on the buyer's representation of the type of financing. Now, why specify? Now, why is that important? So a buyer comes along and says, I got to get a VA loan to buy this house, okay? But the seller, in no way in hell he's going to accept a VA loan. First of all, frankly, I don't know why not, but okay. They got 25 offers on them. They're all cash. They're all more than yours. And buyer's going to have to do a VA loan. The buyer says to the agent, says to us, says, you know, let's write our offer like we're paying all cash, and then I'll just switch it to a VA loan later, and it's all cash to the seller. Anyway, this is already not looking good, okay? All right, already looking bad. And then listen, I'm a big VA guy, so I'm going to tell you, I feel the pain in this, but you know what? Be honest about the type of financing you're going to secure. And I know people in this industry that will tell the buyer or tell the seller that the buyer's paying cash, and then the buyer will rush in the end and try to put a loan on it, you know, because there's a lot of benefits to having a loan, you know, other people's money, the principles of leverage, things like that. It is an untruth. And I would recommend that if you want to have a long and auspicious career, 41 years of doing this, tell the truth. Okay, I know it sounds obvious, but listen. Okay, so including but not limited to, you know, the lawyers wrote that, right? As applicable, all cash, amount of down payment, all cash, amount of down payment, or contingent or non-contingent loan. All right, so let's tell the seller the truth, because the seller is going to rely on that. Things do not go well if you try something funny, okay? And sometimes you'll have buyers do that, and sometimes you won't be aware, but you better be able to defend the fact that you weren't aware of it. And guess what? When they depose all of your emails and stuff, we're going to hope that there's nothing in there about that, okay? I read a lot of emails in my trial work, all right? Seller has agreed to a specific closing date, purchase price, and to sell the property in reliance on the buyer's covenant. Covenant by law is a promise regarding concerning financing. A covenant is a promise, okay? And so the seller, they were telling the seller right away, they were telling the buyer, I'm relying on what you're telling me, okay? And it's a covenant. You're promising me, you know, no, got your fingers crossed, none of that stuff. Buyer shall pursue the financing specified in this agreement, okay? So if you say it's going to be FHA, it's FHA. If it's going to be VA, it's going to be VA. If you say it's going to be conventional, it's going to be conventional. Don't go switching. Okay. Now, I mentioned VA only because VA transactions, I think are actually easier than a conventional transaction, but some people out there think that, oh, it's a VA offer, it'll never close, I got all these problems, things like that. I don't know where you're getting that from. There's a lot of advantages to the VA borrower buying the home. They're much more assured of closing. The lenders won't give VA a non-owner loan. There's a lot of reasons why that's probably a better buyer, but okay, I get it. Okay, so the buyer shall pursue the financing specified in the agreement. Seller has no obligation to cooperate with buyer's efforts to obtain any financing other than that specified in this agreement. So if the buyer decides to change the type of financing, now on a VA, the reason I was using VA as an example is if the buyer decides to change the type of financing, we all know that the lender will not allow the borrower to pay certain expenses, and that means that the seller is going to have to pay those expenses, and the seller is going to say, I'm not going to do it. And you lied. So guess what? You're going to probably put yourself in a problem with that because you told the seller that you were going to get a loan that they weren't anticipating this kind of cooperation, that kind of thing, okay? Stephanie, buyer could switch lenders, but not the type of loan. And the answer is sure, they can switch lenders. I would notify the other agent and therefore the seller immediately if they're going to switch lenders. It happens all the time. I'm going to tell you, sometimes you have problems. Sometimes the lenders can't perform, or sometimes they don't want to perform. But you need to be really transparent with the seller, and you're going to have to do that through the listing agent. If the buyer says, I can't, if the lender says I can't get this loan, and so I'm going to go to this other lender, the buyer says I can't get this loan, I'm going to go to another lender, then you as the buyer's agent should be notifying the listing agent, the seller through the listing agent, that the buyer is switching lenders because they can't get the loan. So I think you need to be truthful about those things, because it's just like, if you had known that at the time of the offer, would you have said it? And the answer is yes, then you need to keep them current. I'm finding that in our transactions, we never lose a deal. I mean, we just don't. Our cancellation rate's 1% over 3 years. You'd never lose a transaction. And there are ways to secure that. Just like we just did the winning listing presentation the other day, we killed it on getting a listing. And now you have how do I write an offer that is just bulletproof? Okay. So great question, Stephanie. Thank you. A seller has no obligation to cooperate with the buyer. Buyer's got to go to VA. They're going to get a VA, or they knew it all along, or they want to switch to a VA because it's got better terms. The seller does not have to cooperate in that. Guess what? The buyer, let's see what happens. The movie is still going, okay? So financing other than that specified in the agreement, and the availability of any such alternative financing does not excuse the buyer from the obligation to purchase property and close as specified in the agreement. So if the buyer says, I'm paying cash, and then goes and tries to put a loan on there, then that's inconsistent with the contract, and this language in here says that it doesn't excuse the buyer. Or the buyer comes in and says, I'm getting conventional financing, and then tries to switch to VA, and then can't get VA, Stephanie, can't get the VA, then they need to go back and get the conventional loan, okay? So, at some point there's a lie, but if it doesn't cost the seller anything, what can the seller really do? There's no damages. But at the same time, you switch to VA, and the seller is going to have to cooperate or not, and the contract says they don't have to cooperate, okay? Thank you all for being here. Again, I wish you the very best. You take care for now. Bye-bye.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.